Disclaimer. I am a law student, and the legal information provided is not legal advice. For that, please hire an attorney. So, Kyle Rittenhouse. Need to get some tea. We're about to spill the tea, so it's only appropriate that I start pouring some tea here. Honestly, what happened to Jacob Blake? I mean, it sucks because, I mean, like, it shouldn't really be that controversial. I don't think that the case is itself that controversial. I mean, like, you know, every single conservative pundit in America has basically tried to, like, justify it by, you know, the things that, by, like, prior criminal histories of Jacob and, like, you know, the fact that, oh, he was no angel, right? Like, let's be clear, from a legal perspective, this does not matter. It doesn't matter in determining whether or not an officer was justified, right? The only way it could possibly come in is if it came into account, like, with an officer's perception of whether or not they needed to use force in a given circumstance, right? Like, that's the only conceivable way that it could come in. And really, I think that, like, the easy counter argument to that is, like, okay, well, did he do any of those things that day, right? Did he do any of those things, like, right before then? It's like, no. All that we have to go on is that he was tased, he got up and walked around to his car, and he got in, and he was shot 7 times in the back. Didn't play Simon Says good enough. You know? So, but that's the background, right? Or at least some of the background. Kyle Rittenhouse has been, I think, probably one of the most divisive subjects. And Kyle was basically what happened, like Kyle as an event, as an idea, is what happened after the shooting of Jacob Blake, right? So let's go back to the USA article that covered basically everything, right? We looked at this a little bit before. We said we were going to be returning it back. We said we were going to be returning back to it. Well, this is Chekhov's gun. We're coming back to it. We did it, fam. We kept the promise. So yeah. Protests grew violent, resulting in the killing Tuesday of 2 people and the arrest Wednesday of a 17-year-old Kyle Rittenhouse. All right. The police shooting of another black man, this time in Kenosha, Wisconsin, has fueled additional alarm and anger over excessive use of force. Jacob Blake was shot 7 times in the back Sunday by a 7-year-old veteran officer, authorities say. The shooting set off protests, at times violent, that drew Kyle Rittenhouse, a 17-year-old white male and self-prescribed militia supporter. All right? We're going to be coming back to that in a bit. Who was charged with shooting and killing 2 people and wounding a 3rd. Here's a detailed look at how everything played out. We already talked about the shooting. Again, for people who are watching on YouTube later on, go back to the earlier video on what happened specifically with Jacob, and there will be more information there. I don't want to dwell too much because we've already talked a lot about the facts, and they are very depressing. Hundreds of protesters gathered as news of the shooting spreads. Kenosha County declares an overnight emergency curfew from 10:15 p.m. Sunday to 7 a.m. Monday. A number of buildings are burned, including a state probation and a parole office. Officers fired tear gas and rubber bullets into the crowd late Sunday. Most of the protesters leave. Monday, August 24th. The city uses garbage trucks to block the Kenosha courthouse entrance at 56 and Sheridan Streets. At least 3 trucks are burned. Firefighters begin cleaning up the damage from the protests. Wisconsin Attorney General Josh Kaul, remember we heard from Josh earlier, announces that the state's Department of Justice Division of Criminal Investigations will lead the shooting investigation. We already talked about that. At 8 p.m. local time, about 125 National Guard members arrive in Kenosha to guard against looting and vandalism and to protect firefighters, Governor Tony Evers says. Tuesday, August 25th. This is the day that we're talking about, right? A lawyer for Blake's family says he's in stable condition but is paralyzed and says it will take a miracle for him to walk again. About 125 more National Guard members are deployed, bringing the total to 250. That evening, protesters and law enforcement clash at a metal barrier outside the courthouse. This is about the demonstrations, right? Demonstrators throw fireworks and bottles at police, who respond by firing tear gas and rubber bullets. Demonstrators are expelled from Civic Park Center as protests continue. Shortly after 10 p.m. local time, armed people, identifying themselves as militia are seen patrolling businesses downtown in a video streamed on social media. We'll be watching everything more. There's another source with all the videos. We'll look at that right after we're done here. We might be a little repetitive, but I want to make sure that at least I would rather be a little repetitive than not include relevant facts, right? So forgive me if we go over things more than once, right? But here it's important, right? Because all the facts sort of matter. Shortly after 10 p.m. local time, armed people identifying themselves as militia are seen patrolling businesses downtown in the video stream on social media. Rittenhouse, the teen later arrested in the fatal shootings, is seen carrying a weapon with this group and being recorded by several people on videos that appear to be on social media, right? Armed people on the rooftop, group of armed people identifying as militia. The teen suspected this is Kyle Rittenhouse, right? And asking police for water. We'll see a clip of that later, but that happened, right? Essentially, the story is that they were trying to protect this building, at least initially, right? Again, we will return to that argument later, but that's what I believe is what they established is what they were there for. At 10:30 p.m., Rittenhouse is seen asking the police for water. At 11:44 p.m., police report 3 or 4 people trying to light vehicles on fire at a car lot on 63rd Street and Sheridan Road in Kenosha, Wisconsin. A few minutes later, an officer advised extreme caution to responding squads. We've seen at least 4 people with handguns running around here. We'll talk about that more later. Around 11:45 p.m., videos capture a figure that resembles Rittenhouse with a long gun being pursued by a second man through a parking lot of a pre-owned vehicle shop on 63rd Street in Sheridan. We will see that later. The pursuer throws an object at him, it misses, and they disappear behind a row of cars. Several gunshots are heard, and people began screaming and running. From what I understand in the court documents that have been released, it was a plastic bottle in a plastic bag, right? That will be relevant later on because some people thought it was like a Molotov cocktail, and the court has determined that is not the case. In the second video, the person with a long gun runs behind a row of cars, pursued by the one who threw the object. A single gunshot is heard. The pursuer is running towards the person with a gun when 4 shots are heard and the pursuer falls, right? So here's like a decent map of it. The person with the long gun pursued by... The pursuer is running towards the person with a gun when 4 shots are heard and the pursuer falls, right? So basically what you have is an instance where someone is chasing after Rittenhouse after shots are heard, right? Thank you for subscribing. After shots are heard. And this is the person that we will see later on, or probably one of the people who was shot, right? Several more shots are heard, and the gunman returns to the shooting victim, who is being aided by a passerby. Someone says, call 911. We'll see this again. The shooter pauses to look at the body, then backs away and pulls out a phone. The man helping the victim rips off his shirt to stop the bleeding from the victim's wounds. As more people arrive, it appears that the shooter begins running. He is holding a phone to his ear, though the audio is muffled, says what sounds like, I shot somebody. As he runs away, people heard him screaming he shot him. We'll be seeing more of this as well. Again, we will be repetitive. I would rather be repetitive and make sure we all know what we're talking about than not repetitive and don't have the facts straight. Okay? So here is actually a really good infographic of the suspect running. This is Rittenhouse. And here's the camera, right? And you have Rittenhouse running, and there's his gun. He's identifiable by the green shirt and the orange bag, right? As he is running, several people are seen attempting to intercept him. He falls to the ground near 61st Street and Sheridan Road. A few people begin to run at him. The shooter ultimately fires 4 shots at 3 people who rush towards him, hitting 2 of them. This is ultimately the major issue, all right? There are other instances of violence, but this seems to be the one that most of the internet is really, really trying to grapple with, right? What you have is, and we'll see more of this, right? This is Rittenhouse. This person, or I can't remember if it's this person or another person. Someone runs up to Rittenhouse and basically like runs over him. This may or may not be him. We'll watch the video in a second. And this is someone who, and it's a little clearer in the video, has a handgun, right? He does. It's pretty clear. One of the victims is briefly on top of him with a skateboard against his body. He shoots that person in the chest and he rolls off. The victim stumbles forward a few paces before he crumples on the ground and lies still. The last victim, who's carrying a handgun and a cell phone, is running away towards the shooter when the skateboard is shot. A foot or 2 away, he covers his head with his hands and pauses for a moment before moving towards the man with the rifle again, who shoots him in the arm. By the way, in case it isn't already apparent, everyone, trigger warning, content warning, 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 warning. If you cannot watch this, please do not. Okay? Okay. The victim runs away, screaming for a medic. A video shows graphic imagery of the victim's wound as a live streamer offers medical help. The shooter continues running towards the intersection. He sees some police cars and raises his arms. The police appear to continue down the road. Okay, I think that this is essentially enough that we have to see from here, because this is pretty fucked up. Actually, no, there's only a little bit more, so we'll finish it. At 11:55 p.m., police audio shows the first report of a gunshot victim. Police said it looked like an injured person had been put in the back of a black SUV. It looks like they're stuffing him into the back of a security vehicle from KMH. Yeah. At 11:52, a police officer says, "We have someone down the middle of the road, CPR in progress." Again, so they're attending to everyone who was shot. 47 seconds later, police reported a person running northbound through 10th Avenue from 6th to 3rd. He dropped his gun. We're holding it right now at 63 and 11. At 11:58, police report 2 civilians in the ER and confirm no officers were down. I have their gunshot victim walking to the ER right now. At 12:12, police officers some additional information. He was running northbound and confrontations. Okay, yeah. Okay. We're going to be talking about this a lot fucking more. All right? Pay attention. There's Kyle, and there's a bunch of police just driving by him. Okay? Literally. Has a gun. Just walking towards the police. Just walking towards the police. All right? Hey, yeah, police, are you gonna... Hey, person with a gun here. Oh, okay, just drive by. Oh, okay. Just gonna ignore this. Yeah. So, what I'd like to do now, here's a New York Times compilation. Here's all the specific footage, right? Now that we've got like a good detailed account of what happened, here's basically what we're going to be looking at. I'm not so interested in looking at all these, like all the writing is essentially the same, right? But there's some really good footage that they've compiled on here, right? So here's an interview of Kyle at the property that he says that he was defending, right?
What are you doing out here? Obviously you're armed and you're in front of this business we saw burning last night, so what's up?
So people are getting injured and our job is to protect this business, and part of my job is to also help people. If there's somebody hurt, I'm running into harm's way. That's why I have my rifle, because I need to protect myself, obviously. But I also have my med kit. We're protecting from the citizens, and I just got pepper sprayed by a person in the crowd.
So you had non-lethal, but you didn't respond.
We don't have non-lethal.
So you guys are full on ready to defend the property?
Yes, we are. Now, if I can ask, can you guys step back? Medical, EMS right here. I'm an EMT. I am an EMT.
My job. You don't have a job, you fucking LARPer. Yeah, we'll be talking about this more. But essentially what he is saying right now is that, like, there is some legalese to this, right? He's saying that he is, right now, defending property and is justified in using that firearm if he needs to in order to defend that property, right? That's essentially what is important to take from here, right? We'll talk about this more in a bit, but that's important to take from here. And yeah, I'm a medic. I'd be interested to know how many lives he saved that night, because he sure took a lot more. Be really interested to know how many he saved. First shooting. While Mr. Rittenhouse is being pursued by the group, an unknown gunman fires into the air, though it's unclear why. The weapon's muzzle flashes. Excuse me. I don't know why I'm burping so much. The weapon's muzzle flash appears in the footage in the film scene. Mr. Rittenhouse turns towards the sound of gunfire as another pursuer lunges towards him from the same direction. Mr. Rittenhouse then fires 4 times and appears to shoot the man in the head. Is there not a video here? I think that we'll be having a video of this in a little bit, right? Mr. Rittenhouse seems to make a cell phone call and flees the scene. Several people chase him, some shouting, "That's the shooter," right? And that's how we arrive at this. All right, so that's a video. As Mr. Rittenhouse is running, he trips and falls on the ground. He fires 4 shots as 3 people rush towards him. One person appears to be hit in the chest and falls on the ground. Another who's carrying a handgun is hit in the arm and runs away. Mr. Rittenhouse's gunfire is mixed with the sound of at least 16 other gunshots that ring out at this time. Okay. It's the first person to run up. Trips and falls. Someone runs at him, jumps on him. Gunshots. Another person with a skateboard. All right. I might go back through this just for a play-by-play. 2 shots. Shot in the chest, shot in the arm. Handgun is pretty visible, right? Let's go over it just one more time. Rittenhouse. First person to run at him. A lot of people chasing him. Falls on the ground. Person runs up and jumps on him. First shots. Other person with a skateboard. More shots are made. Other person shot in the arm, handgun, shot in the chest, Rittenhouse. All right. These are the moments that the internet is basically exploding over right now. Just to be clear. All right. So that's what happened. There's a little bit more, but those are the major moments, right? And then, of course, in case you didn't hear it, I'll rewind. I want you to listen for what other people are screaming in the background. That's the shooter. Just walks towards the police. After people behind him scream, that's the shooter. Someone screams, he just shot them. Everyone is... Now, again, all right, you're gonna have to pretend like you didn't see this already, but let's play with a hypothetical, or I'll just ask you all a question. Someone with a gun is walking towards the police, and and there are multiple people screaming in the background that person had shot someone. How do you think that the police will respond? Will the police respond A, by shooting that person, B, by stopping and arresting them, or C, doing absolutely nothing? Leave your comments in the chat, or don't. I don't care, because the world is on fire.
Someone injured straight ahead. No! Get out of the road! Get down there! God damn it!
Literally, just walks by all the police. Yeah. Now, I can't remember if it's mentioned here or elsewhere, but he wasn't arrested until about, I believe it was 2 days later. Just let that sink in for a second. Was not arrested for like 2 days after this. So here's the response by Kenosha police. We heard a little bit about it. I think that there's some other footage, but yeah, the fact that they gave him some water. Let's see. Moments before. Local law enforcement thanked the alleged shooter, 17-year-old former police cadet Kyle Rittenhouse. This is new. I actually didn't realize this. He was a police cadet. Much more. It's all interesting, isn't it, people? We keep discovering more and more about his history and his so-called militia colleagues for being on the scene. One sheriff deputy gave Rittenhouse a bottle of water, right? So they're familiar with the police. They had already known them, but he palling it up. I don't know if we're going to get into it here, but I know that on Facebook, Kyle also has like a lot of pictures about how he's like a big fan of Blue Lives Matter. He's part of like several Facebook groups that effectively promote those sorts of ideas. So just to give you an idea of who we're talking about, that's who we're talking about, right? And here are the charges so far. All right. Kyle Rittenhouse, the Illinois teenager accused of shooting and killing protesters in Kenosha, Wisconsin, has been charged with 6 criminal counts, including felony charges of first-degree reckless homicide, first-degree intentional homicide, and attempted first-degree intentional homicide. All right. Rittenhouse is also being charged with 2 counts of recklessly endangering safety and possession of a dangerous weapon while under 18, which is a misdemeanor. We will come back to more. That is a surprise tool that will help us later. All right. But that's all that we need from there. Is there anything else? Nope. Okay. That's all that I wanted from there. So that was a lot of context, right? And I'm glad that you all have stuck with me. Again, we're on this harrowing journey together. We will go down into the pits of hell, and we're going to come back. We're going to come back stronger because of it. Or maybe we won't. I don't know. But knowledge is power, supposedly. So here are the main issues, at least as I see it. First, did Kyle Rittenhouse act, A, or 1, within the boundaries of the law in what he did, and 2, in a morally correct manner? The second analysis will be much shorter and towards the end, because I give political commentary in addition to trying to teach a little bit about the law, at least to the extent I'm able to, right? These are 2 different questions, but they're a little bit related, right? So, yeah. But just because this is a really long and a really, like you're going to quickly realize this is a really complicated discussion. I get that a lot of people might think it's super clear and super clear cut. It's not. It's really not, right? So I'm going to try and make things as easy and accessible to everyone as possible. And so this is going to be the order of our discussion. First is the common law as it relates to what law might pertain to the situation and how charging someone works, right? We know what the charges are. We're going to kind of explain to people how charging works, right? Secondly, we're going to discuss Wisconsin's specific law, right? Because first we're going to talk about common law. That's court-made law. That's not necessarily what applies to every state. Just about every state will employ some variation of common law. And for the most part, it will be the same. But there can be small differences, and those can sometimes be important. 3 will be the analysis, and lastly will be the moral argument. Okay? So that's what we're going to do. Everyone strap in. I'm going to take a sip of tea. Let's ride. So the first question that we have to start with, can anyone tell me, this, if I was a law professor, this would be what I'd ask right now. Can anyone tell me what homicide is? I'm actually going to give you all a chance to write it in the comments because I'm actually curious of what people think, because this is something that everyone is talking about right now and a lot of people don't know. So, hey, chat, especially Discord chat, because I pay attention to you. What is homicide? Some good tea. When you kill someone, killing a person, states' rights to discriminate. When you intentionally killing a person, killing without intent, killing of another person. Okay, these are decent guesses, right? So at common law, and thank you for, actually, I really like being able to have audience participation. This is great. I really enjoy this. So what's important to recognize with homicide is that homicide is the killing of one human being by another human being. All right, broadly speaking, that's all that it is. It's just the killing of one person by another. Boom, that's homicide. Now, criminal homicide is the unlawful killing of one human being by another. Very broadly speaking, because sometimes homicide is legal. See the death penalty. Yeah. which kind of sucks, but there's a distinction to be made there. And there are 3 homicide crimes under common law: murder, voluntary manslaughter, and involuntary manslaughter. All right? Are you being graded? Yeah, you all failed. Actually, no, you all get a pass. Congratulations. Or at least the majority of you. I'll single out one of you later. See me after class. For some reason, there's a typo. Hey, wow, thank you for donating. Thank you for taking time to talk about this. I appreciate it. Yeah, no problem. So there's a typo here. There's supposed to be, what are the elements for common law murder and involuntary manslaughter? All right. So common law murder, I kind of want... Actually, you know what? Hold on. I've talked about this on stream before. Y'all better fucking know this. Tell me what the elements for common law murder are right now. If someone doesn't get this, I'm going to throw such a fit because I've talked about this. I cannot tell you how many times I've talked about this on stream before. Someone tell me that you've learned a damn thing and tell me what the fuck common law murder is. I know I've talked about it on here before. I use it as an example constantly. All right? You've all failed me. God damn it. All right, wonderful. Well, you're actually learning something today, so pay attention. Okay? You're actually learning something. All right? So common law murder is the unlawful killing of another with malice of forethought. All right? Broadly speaking, that's it, right? Thank you for subscribing. But yeah, broadly speaking, that's all that common law murder is, right? Now, there's a lot that goes into those various elements, especially malice of forethought, but we're probably not going to be talking about that here so much. Involuntary manslaughter is a lesser but included offense which lacks malice of forethought, right? Just to give people an idea, malice of forethought is a legal term of art. It can encompass a number of different theories, like acting with intention to cause death to someone, or acting with intention to cause grievous bodily harm to someone, or acting with knowledge that you would cause death or grievous bodily harm to another person, or acting with a depraved heart, which effectively is the idea that you well should have known that your actions would have led to the death of someone. A famous case example of that is really gruesome. Essentially, it was where there was a high schooler, a high school guy who had a party at this house, and there was a girl who got drunk there. And he essentially, it was in the middle of winter, and and they got drunk, and they had sex, and he, after they had sex, dragged her outside, while she was wearing nothing but, I think it was just a shirt, and just left her out there. And she died. There's an argument that because he was intoxicated, he didn't really have intention to kill. But this is kind of the instance that we would say that he was acting with a depraved heart, where any reasonable person well would have known that what they did would have resulted in the death of another person. Rip to my spoons. Damn it. Y'all made me laugh too much. Oh my god. Ow, that actually hurt a little bit. Got some tea onto my eye. Hold on. How's it look? Okay, it's fine. So yeah. Oh, and he was certainly, yeah, he was convicted of murder for sure. Yeah. And that's how that went over. But yeah, so malice of forethought can mean a number of things. Involuntary manslaughter is just the same thing, but it lacks malice of forethought, right? Now, mens rea marks the principal difference between the two. Murder requires malice of forethought, and voluntary manslaughter does not. It just requires malice, which can be a little misleading given the name of the crime, right? Involuntary manslaughter sounds like there's some involuntary action that's required for it, but no, it's just a lesser mens rea requirement. That's it. You could be our 900th member joined today. Nice. So what are the elements for common law voluntary manslaughter, right? Under common law, voluntary manslaughter is when an intentional killing that would otherwise be murder, all right? With the unlawful killing of another with malice of forethought. Voluntary manslaughter is when an intentional killing that would otherwise be murder is mitigated to manslaughter, is done in the heat of passion on sudden provocation, right? There are 4 basic elements required to mitigate an intentional killing to voluntary manslaughter. First, the killing must be done in the heat of passion, which is a state of high emotion that affects one's ability to control his thoughts or behavior, right? 2, the defendant's heat of passion must be in response to sudden provocation, i.e. if there's a period of time between the provocation and the killing that is sufficient for a defendant to cool off, then the intentional killing is murder, not voluntary manslaughter, right? Note that there is no hard and fast rule as to what length of time is sufficient to serve as a cooling off period. A lot of it depends on the circumstances and the nature of the provocation, right? In addition, the defendant's heat of passion in response to a past provocation can be reinvigorated by events or even by perseverating thoughts. The final determination as to whether there was time to cool off is often left to the finder of fact, i.e. the jury, right? 3, the nature of the provocation must be such that would lead a reasonable person of average emotional fortitude to act in the heat of passion. And lastly, as a general rule, insults and other verbal provocations are not regarded as sufficient to warrant mitigation of murder to manslaughter under the common law. Sticks and stones and all that, right? The exception to this rule is for words that describe events or circumstances which, if observed directly, would be reasonably provocative. The example that my law school professor used for this, let's say that you are a woman in an emotionally abusive relationship. And let's say that your husband or wife or whoever constantly makes fun of the fact that you have... I think that the example that he used was, in this case, it was... I can't remember what it's called. It's like the disorder where you have a deformity where... Or it's like a mental condition where you actually overly perceive flaws of your body as negative, right? So, like, I think that in this example, the woman thought that her feet were way too big, and it constantly gave her, like, effectively, like, a kind of dysphoria. Or I guess in this case, it would be dysmorphia, right? And the husband or the partner knew about this and actually constantly provoked the woman, the partner, in such a way as to intentionally try to provoke her, right? Well, eventually, the hypothetical goes that one day he tried doing this and she just fucking snapped in response and beat the husband over the head with some blunt object, right? That would probably be a good example of voluntary manslaughter, right? Where it's like, yeah, she killed the person, but also she acted the way that any reasonable person would in response to a provocation that would lead a reasonable person of average emotional fortitude to act in the heat of passion, right? It's essentially what that is. It's probably not relevant for here, but it's one of the main theories of homicide, so it's good to cover. So now that we've gone over, like, those are essentially the main common law offenses that Kyle could be charged with, right? Under the common law. We'll talk about under the state law more specifically, but that's common law, right? Now, defenses, what's important to recognize is that there are 2 different types of defenses, but in order to be able to use a defense, basically, well, we'll talk about that, right? The first type of defense is negative, where you just try to prove that one of the elements for a crime is not met, right? If you got murder, unlawful killing of another with malice aforethought, you just prove that one of those things isn't met, boom, done. Case falls apart, right? In order to prove murder, you have to satisfy all of the requirements, 100%, and anything less than that, you don't meet it, all right? But the other type of defense is affirmative, where you concede that I guess it's not committed the crime, that's probably actually bad wording, but where you can see that you meet all of the material elements for the offense, but you argue affirmatively that you were legally justified in doing so, right? This is probably what we're going to be talking about here. And the reason this is important is because we start with the analysis of these are the types of crimes that Kyle meets all of the material elements for, and then we go into, okay, are there any affirmative defenses that he could bring up to otherwise try to get rid of the charge or mitigate it to a lesser degree, right? That's essentially where the discussion goes, and that's why this is relevant. So what are the 2 main types of affirmative defenses? Affirmative defenses fall into one of 2 different categories, right? The first is justification defenses. This is where someone admits the material elements of all the crimes, of the crime, but maintains that in light of the circumstances, all things considered, that the defendant did the right thing. In other words, that she was justified, right? Oh crap. Whatever. Necessity and self-defense are justification defenses, and these are the ones. Disclaimer. Hey, heads up. These are the ones that we're going to be talking about. The other types of affirmative defenses are excuse defenses, which admit the material elements of the crime, but maintain that in light of the circumstances, defendant is not fully culpable, or that punishment is unwarranted, right? So what would these be? These would be like duress, intoxication, entrapment, and insanity, right? Like things where it's like, I did the crime, but like, I had no control over it, all right? I was drunk, I was being forced to, I was entrapped by the government, which is a thing, or I was... Insanity isn't a great term, and it's being phased out of the law, but that's how it used to be said, right? I think that the term that's normally trying to be used nowadays is mental impairment, or I actually can't remember it. Is that where transpanic defense comes in? I think so, as far as I'm aware, right? Because basically, necessity and self-defense, it would be excuse offenses, right? So basically that they were under such duress, that they were so shocked by, oh my god, she has a penis or whatever, right? That any reasonable person would have acted in the way that they did, i.e. by murdering the person, right? Which is crazy and terrible, but yeah, that's essentially the logic for the transpanic defense. The more you know. So yeah. So what is the affirmative defense of necessity, and what are its elements, right? Because so basically we're going to be looking at two major defenses that Kyle could bring up at common law: necessity and self-defense, right? Necessity can provide a partial defense in circumstances where a defendant's crime is reasonably calculated to prevent an imminent greater harm, and can provide a full defense, a complete full defense, where 1, by virtue of the circumstances; 2, not of the defendant's intentional, knowing, or reckless creation; 3, there's an immediate; and 4, emergent threat; 5, of significant harm; and 6, the defendant commits a crime; 7, that is reasonably likely to prevent that harm; and 8, the harm caused by his crime is substantially less than the harm prevented; and 9, the defendant had no lawful or reasonable alternative; 10, of which he was or should have been aware. I know it's a lot. But we're going to be talking about specifics, all right? So there's this question of what happens when an actor acts out of necessity, but does so in response to dangers which the actor herself brought about through her own negligence or recklessness, right? What happens when, yeah, you act out of necessity, but it's like you also kind of put yourself into the position where you needed to act out of necessity, right? What happens there? Under the common law, and in most jurisdictions, what will happen is that she will qualify for what's called an imperfect defense, all right? Depending on the nature and the degree of the imperfection, this would qualify him for a partial defense. The degree of the mitigation might be a simple downgrade from, say, murder to voluntary manslaughter. This would at least be the result under the Model Penal Code section 3.012, right? The Model Penal Code, for people who don't know, is basically the idealized form of what criminal law should be. It's drafted by the American Bar, or I believe it's by the ABA, or it's another like reputable organization, which basically says, hey, and it's like comprised of like legal professionals, legal scholars, etc. And it's basically like them saying, hey, judges, you don't have to adopt this, but like it's what all of the professionals in the field says that should be adopted, right? So you totally should consider it. Hot take. So that's what the Model Penal Code is in a nutshell. Some jurisdictions take a slightly different view, holding a responsible for involuntary manslaughter in light of his recklessness in creating the risk. Mistakes as to other elements, such as the existence of the threat, its immediacy, and the force used, could also result in an imperfect defense claim that would not lead to a full exoneration, but might well provide grounds for mitigation, right? So, like, essentially what would happen is that, yeah, you're not going to get charged with murder, but you will probably get voluntary manslaughter, is likely what would happen, right? That's the most likely outcome of using one of these defenses, because you still kill someone, right? There's still a dead body. And especially if it's like in circumstances that you well could have avoided, then this is probably what will happen in most circumstances. Then there's this question of what is the affirmative defense of self-defense and what are its elements, right? Self-defense is a special case of necessity that covers the use of deadly force against a person engaged in an unlawful use of force that threatens the life of another. The elements of common law self-defense claim are A, the defendant actually, and 2, and reasonably believes that the victim is in or is threatening to engage in. Side note on this element, this means that honest and reasonable mistakes as to the threat may still provide a full excuse, right? If someone makes a mistake, but they make a mistake that any reasonable person would in the circumstance, then that could still work. Good to note of here. The unlawful, 4, use of force. 5, that poses a risk of death or severe bodily harm to the defendant or third party. 6, that the risk is imminent. 7, the defendant did not initiate the confrontation with the victim. 8, the defendant uses force that is 9, reasonable, and 10, necessary to terminate the threat. And 11, there is no reasonable opportunity to escape or the defendant was not aware of a reasonable opportunity to escape. I don't know why I'm burping so much tonight. Question of the day. Could Kyle have avoided murdering 3 people in a short time span as part of his militia work? What an interesting observation. Side note about the necessity to terminate the threat. Because actually, I think that people kind of maybe picked up on that. In a claim of self-defense, what does it mean that the use of force, deadly force, must be reasonable and necessary? As a general rule, the use of deadly force is only appropriate if necessary to save a life. Okay? That's generally what that means. The use of deadly force is only appropriate if necessary to save a life. Here's a good way that my professor actually put it. Pulling a knife in the middle of a good old fist fight is excessive. So too would be the use of deadly force to prevent an unarmed larceny. This requirement is therefore linked intimately with the nature of the threat. Threats of minor physical injury or the loss of property do not warrant the use of deadly force. There are no bright lines here, of course, so it may well be reasonable to use deadly force against an unarmed mugger even if he makes a traditional offer, your money or your life. Perceptions also matter. For example, in the infamous case of Bernard Gotez, who shot 3 teenage boys on the New York City subway train in 1984, Gotez cited the fact that there were 3 of them, that they were in close proximity to him, that they had been giving him what looks like they wanted to mess with him, and that one of them asked him for his money as grounds for his belief that he had to use deadly force to defend himself. These facts hardly seem sufficient to support a reasonable belief that deadly force was necessary, but a New York jury acquitted Gotez. Their decision likely reflected some common experiences with crime in the city during that period. All right? So again, it's important to note here, a lot of this goes back to this idea of perception. This doesn't really have to deal with whether or not Kyle was correct in what he thought at the time about what the other people were going to do to him, but whether or not he had a reasonable perception, whether or not it was a perception that any other reasonable person would also have if they were in the same position. That's what the law looks at, right? At least at common law. Okay, so let's have a review. 1, you start with whether he committed homicide, right? That's where we start with. Murder, voluntary or involuntary manslaughter. 2, then if the defendant meets all the material elements of homicide, then you look to see if he meets any justification defenses. In this case, either necessity or self-defense. Okay? We're all good? Awesome. Tea break. RGR, so they were going to take my gun. Isn't an excuse to shoot someone? I'll let y'all decide. So, all right, that's basically the common law. Congratulations, y'all just got a primer on like half of a course of criminal law. Hooray! Now you don't have to pay for law school tuition. Amazing. So that's basically the coverage of common law. That's what most people would learn if they were to take an introductory common law or a criminal law class in law school. At least on the relevant subjects, right? Now we didn't get into like what is like actus reus or mens rea requirement, but that's not necessarily like as required for this kind of a discussion. Because that has to do with like whether or not someone had the requisite mindset, or whether or not someone indeed committed an act, and whether or not there was a result, right? Most of those are kind of moot issues, right? And they only come up in like very specific cases. So yeah, with all of that being said, let's talk about Wisconsin specific law. Wisconsin state law, section 940.01, first degree intentional homicide. Now remember back when we read about like the things that Kyle was charged with, this was one of them, right? So, except as provided in subsection 2, wherever 1, someone causes the death, actus rea, 2, of another human being, 3, with the intent to kill that person or another, is guilty of a Class A felony, right? That's very similar. It should sound similar to people who have been paying attention. It basically maps onto what we had talked about earlier. Again, that's kind of like where the discussion of like where common law and like state law overlaps. It's often very, very similar, right? And this is very similar to what we had talked about earlier, right? Causes the death of another human being with intent to kill that person or another. That's first degree intentional homicide, all right? Now, the law also comes with mitigating circumstances. The following are affirmative defenses to prosecution under this section, which may mitigate the offense to second degree intentional homicide under section 940.05. The first is adequate provocation, that the death was caused under the influence of adequate provocation as defined in 939.44. B, unnecessary defensive force, that death was caused because the actor believed he or she or another was in imminent danger of death or great bodily harm, and that the force used was necessary to defend the endangered person if either belief was unreasonable. And C, the prevention of felony. Death was caused because the actor believed that the force was necessary to exercise in the exercise of the privilege to prevent or terminate the commissions of a felony if that belief was unreasonable. Okay? So we have the law here. Going back to our discussion, basically where you start is figuring out, okay, do we meet all the elements for this? All right? And if you do, then you go to these. All right? Step 1, are these met? Step 2, all right, if step 1 was met, then we go to look at all these. All right? Cool. This should start feeling familiar at this point, right? We've done a lot of like the primer work. So now people should start being able to follow a little bit easier. So the other thing that he was charged with, or one of the other things that he was charged with, was section 940.02, first degree reckless homicide, right? Slightly different, not intentional, reckless. Let's explore. Whoever, 1, recklessly, 2, causes the death, 3, of another human being, 4, under circumstances which would show utter disregard for human life, is guilty of a Class B felony. A lot of these should look very similar, especially cause the death of another human being. The difference is recklessly and under circumstances which would show utter disregard for human life. We'll explore a little bit about what these terms mean, right? But those are the main differences. The other Wisconsin state law that's good to bring in right here is second degree reckless homicide, which is just whoever recklessly causes the death of another human being is guilty of a Class C felony. Literally the same, except it doesn't have the fourth requirement, under circumstances which show an utter disregard for human life. What that means is kind of wonky and probably depends a lot more on how the courts in Wisconsin have interpreted that to mean. But that's the only difference, right? Riley, seriously discussing law and politics, chat. Also, listen, y'all are keeping me sane right now because this was a lot of work to put together. So, and it's also taken a heavy toll on my soul. So y'all are keeping me sane and happy. I appreciate it. All right. So these are the different degrees of reckless homicide. So going back to what we were talking about earlier on the difference between intent and recklessness, because these are the different kinds of mens rea that's being used in the different Wisconsin laws that we're talking about, right? Recklessness is usually defined as engaging in conduct despite awareness of a substantial and unjustified risk of a fact that exists, that a result will occur, or that his act constitutes the kind of conduct prohibited by law. Basically, it's similar to depraved heart. It's you did something knowing that there was a possibility of a certain outcome, right? Disclaimer, Chad is not a psychologist. That's fair. But yeah, so recklessness is basically the idea that like you act knowing that there is a possible outcome that could happen, right? In this case, you do something knowing that, yeah, there's a good likelihood that someone could die, right? It is important to note that recklessness is a subjective standard, though. To meet her burden of proving recklessness, a prosecutor must therefore prove that the defendant was actually aware of the risk, and the fact that she should have been aware is not enough. This is different from an objective standard, and this is where it's different from depraved heart, right? Depraved heart would look at what any reasonable person would believe, more or less. This is more of, was the defendant actually aware that when he brought a gun to an event that someone could die? Now, personally, I think that's pretty easy because, like, yeah, if you bring a gun to an event, then I think it's pretty likely that you know that someone's going to die, but we'll talk about that more later. But yeah, so that's basically what recklessness is, right? Did the person know that it was possible that if they brought a gun to this event that someone could die? Now, to prove intent, prosecutors generally must prove that the defendant acted with the goal of engaging in the prohibited conduct or of bringing about a particular result. When required to prove intent with respect to fact elements, however, it is generally sufficient to prove knowledge, or under the Model Penal Code, just that there was a high probability that he believed the fact existed or that a result would occur. Basically, when he shot people, was he intending for them to die? Again, I think that the analysis is pretty simple there, but we'll come back to that in a bit. All right, but that's essentially intent. So let's do some analysis, all right? First degree intentional homicide. Causes death. Did he cause death? Yeah. Of another human being? Yeah, dead body. Actually, I think multiple dead bodies. With the intent of killing that person or another human being? Very likely, yes. Again, all of these are likelihoods. I'm not trying to come to any like legal conclusions. These are just like, we're talking educationally here, right? That's all that we're doing, just to be, again, very clear to everyone. Therefore, I think it's likely that a court would find that he committed first-degree intentional homicide, right? Again, mitigation factors aside, which we'll discuss later, but, I mean, like, there's a pretty good case for it, right? I'm also getting better quality. Oh, Twitch is about 4 to 5 seconds ahead of YouTube. Oh, interesting. So, analysis, first-degree reckless homicide. 1, did he act recklessly? Well, probably. Since it's reasonable to expect that Kyle would have been aware of the risk that someone could have died by bringing a gun to a protest, right? Like, if you bring a gun somewhere and you don't know that that gun can harm someone, there are other problems with your mental thinking, right? Again, this is something that will probably be disputed in trial. But you know, there's a good chance that it would be met here. Did he kill someone? Again, yes. Kill someone else? Yes. There's another dead body, and he didn't kill himself. Did he show an utter disregard for human life? This is going to be something that's probably going to be left to the jury, right? It's arguable, but it will likely be determined by the trier of fact, right? At the end of the day, right? And this is something which, again, the attorneys are probably going to be fighting over about how to persuade the people in the jury, right? Yeah. Therefore, it is possible a court would find that he committed first-degree reckless homicide. Not guaranteed. And I'm not talking about guarantees, but the case is definitely different in consideration compared to intentional homicide. Possible defenses. All right. So we started off with the charges, at least the most pertinent ones, right? The killing, right? So let's explore some possible defenses. I feel like we're getting. So under Wisconsin law, specifically section 939.47, this is necessity, right? Necessity is pressure of natural physical forces which causes the actor to reasonably believe that his or her act is the only means of preventing imminent public disaster or imminent death or great bodily harm to the actor or another, which causes him or her so to act, is a defense to prosecution for any crime based on that act, right? Except if the prosecution is for first-degree intentional homicide. The degree of the crime is reduced to second-degree intentional homicide, right? We talked about that a little bit earlier. If they were able to prove the elements of intentional homicide, first-degree intentional homicide, this would only mitigate it to second-degree, okay? If they were able to prove it. And then, under section 939.48 of Wisconsin law, self-defense and defense of others, 1, a person is privileged to threaten or immediately use force against another for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his or with his or her person by such another person. Okay? Again, like a lot of the language will be very kind of dense and it might not make a lot of sense. Refer back to our discussion before, like the common law discussion. It's pretty similar. I'll point out where it's different, but back then I explained it a lot cleaner. That's why we did that before now, right? The actor may intentionally use only such force or threat thereof as the actor reasonably believes is necessary, absolutely required to prevent or terminate the interference. The actor may not intentionally use force which is intended or likely to cause death or great bodily harm unless the actor reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. The TLDR, he had to believe that he had to use the gun to prevent great bodily harm or death, right? Bottom line from that. Also, if an actor intentionally used force that is intended or likely to cause death or great bodily harm, the court may not consider whether the actor had an opportunity to flee or retreat before he or she used the force and shall presume that the actor reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself or herself if the actor makes such a claim under I can't remember where it actually gets cut off there. So basically, the court in this case, again, whether or not people believe that the court should consider it, will not consider whether or not he had an opportunity to flee. So this is a little different from common law. Now, I'm going to say it. We'll talk about it a little bit more in the bit, but I have thoughts on that. But that all being said, oh shit, sorry. I have a stream deck right now, and I accidentally touched it. So, it is at least working as it's supposed to. All right. It's important to note that there are limitations on the use of self-defense under Wisconsin law, right? So, specifically under this section, provocation that affects the privilege of self-defense as follows. Now, this is very important, all right? And this is probably going to be the main part of this case. A person who engages in unlawful conduct of a type likely to provoke others to attack him or her and thereby does provoke an attack is not entitled to claim the privilege of self-defense against such an attack, except when the attack which ensues is of a type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. In such a case, the person engaging in unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to use force intended or likely to cause death to the person assailant, unless the person reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm at the hands of his or her assailant. What does that mean? If he acted unlawfully in bringing about the circumstances that led to the homicide, even if he was acting in self-defense, he can only do it, he can only resort to those actions if he honestly and actually used, let me get the, reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. That's the only time that they could use this defense, that he could use this defense, if he was doing something illegally that brought about the circumstances, right? So back earlier, the discussion about like, oh, well, the court won't consider whether or not he had the opportunity to flee. Well, now we're back on that, baby. We got it back. We got it back. Congratulations. Or at least we might, depending on unlawful conduct, right? Now some people might be thinking, well, what unlawful conduct was he doing? Well, we'll talk about that in a second. Also, the privilege is lost. There's a couple other ways that this is applied. The privilege is lost by provocation may be regained if the actor in good faith withdraws from the fight and gives adequate notice thereof of to his or her assailant. A person who provokes an attack, whether by lawful or unlawful conduct, with intent to use such an attack as an excuse to cause death or great bodily harm to his or her assailant, is not entitled to the privilege of self-defense. And finally, the privilege of self-defense extends not only to the intentional infliction of harm upon a real or apparent wrongdoer, but also to the unintended infliction of harm upon a third person, except if the unintended infliction of harm amounts to the crime of first degree or second degree reckless homicide, homicide by negligent handling of a dangerous weapon. There's a couple different examples here, right? The main ones we're going to be looking at are here, and to an extent here, right? And this is the last one that we have to talk about. We're going to talk about all the laws available before we talk about the analysis, right? And this is another Chekhov's gun, right? Remember when we talked about earlier how he was saying that he was, that he was defending property? Well, this would be the appropriate statute, right? Section 939.49, defense of property and protection against retail theft, right? Here we are. Amazing. A person is privileged to defend a third person's property from real or apparent unlawful interference by another under the same conditions and by the same means as those under and by which the person is privileged to defend his or her own property from real or apparent unlawful interference, provided that the person reasonably believes that the facts are such as would give the third person the privilege to defend his or her own property, that his or her intervention is necessary for the protection of the third person's property, and that the third person whose property the person is protecting is a member of his or her immediate family or household, or a person whose property the real person has a legal duty to protect, or is a merchant and the actor is the merchant's employee or agent. An official adult or employee or agent of a library is privileged to defend the property of the library in the manner specified in the subsection. All right? Cool. That was a lot. A lot of this is word soup. I'll explain it, right? So quick recap. First degree intentional homicide? Probably, depending on the defenses, right? First degree reckless homicide? Possibly, but will depend on the jury. Second degree reckless homicide? Almost certainly. Possible defenses, necessity, self-defense, defense of property. All right? Cool. I'm so glad that we're all getting there. Again, this was a lot, but I got a lot of help from people in my Discord, so I really appreciate the help, everyone. What is property anyway? Yeah, I know, right? But anyway, this is basically where we're at. So let's do some analysis. Now we've done all the groundwork. Let's finally do some analysis. All right? Necessity. It is certainly possible that Kyle may have genuinely believed that his act was the only means of preventing imminent public disaster or imminent death or great bodily harm to himself. It's certainly possible, you know? Given the footage that we see and the people that run up on him, and mind you, I'm about to say, again, people, I'm just applying the law as it exists, right? We'll get to my moral opinions on everything that happened, but this is just how I know the law to interact here, all right? Given the footage that we see and the people that run up on him, especially the one of them that had a gun, right? It could very arguably lead a reasonable person to believe that he needed to resort to using lethal force to protect himself. It could. But remember that the common law is not clear on this and tends to only allow this defense when the person reasonably believes that he needed to use deadly force to save his own life or the lives of others. This is unclear here and will likely be determined by the jury, right? In any case, if the prosecution succeeds on the charge of first-degree intentional homicide, this will only reduce it to a second degree, right? Even if they get this defense to work, it'll only mitigate it if they're able to prove first-degree intentional homicide. Self-defense analysis. This is very similar to the first analysis, but requires more attention to specific language. Here, the statute is more clear that the actor may not intentionally use force which is intended or likely to cause death or great bodily harm unless the actor reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. Again, this will primarily be left to the trier of fact, right? But remember, we're going to be bringing this back up. I want to read it again. A person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke an attack, is not entitled to a claim of the privilege of self-defense against such an attack, except when the attack ensues is of the type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. In such a case, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant unless the person reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm at the hands of his or her assailant. Okay? This is very important. Because let's talk about possession of a deadly weapon. This is what I think is perhaps the most important fact in the entirety of this case. All right? And also in the moral analysis. We'll talk about it later. But this is, I think, what is the single most important analysis in the entirety of these events. Under Section 94860-1, or Section 1, Subsection 1, in this section, dangerous weapon means any firearm, loaded or unloaded, any firearm. And 2, any person under 18 years of age who possesses or goes armed with a dangerous weapon, as defined here, is guilty of a Class A misdemeanor. If you are under 18 and you have a dangerous weapon, including a firearm, loaded or unloaded, that is a Class A misdemeanor. That's illegal. You remember from earlier the discussion on whether or not you are engaging in an unlawful act? Remember that? Chekhov's gun. I think that this is what I was talking about. Remember the surprise tool that'll help us later? So was he acting in defense of property? This is the first one. This is the first analysis that I want to get through. It's actually pretty simple. Likely not, since at the time of the killings, he had left the premises of the property, even if he was able to otherwise satisfy the requirements of defense. Super easy. We can basically toss it aside. Next one. What this means is at the time that Kyle was at this protest, he was not acting in a lawful manner under Wisconsin law at any time that he had his firearm. Since he was under 18 at the time, he will likely be found guilty of at least a Class A misdemeanor. So, if this case goes to trial, Kyle may be able to make an argument for self-defense, may be able to, but it will likely be qualified under the limitations of Section 939.482A. Okay? This will likely be where the main battle will be fought if this goes to trial, in my opinion, right? Just based on what I know about criminal law, which is going to be limited. It's going to be less than like a practicing attorney, right? But this is where I think the main battle will be fought if this goes to trial, and ultimately the case will turn on whether the jury finds that Kyle, A, reasonably believed that his life was in danger, and B, that he had absolutely no other alternatives available to him. Okay? That's my opinion. My non-legal, my just law student disclaimer opinion. Just in my personal opinion, me acting in my own personal capacity, how do I think the jury will find if this were to go to trial? It's hard to tell, right? It is. I know that people want straight answers here, but juries do crazy things all the time, all right? I have no idea. I don't. And I don't want to try and assume that I know, you know? Given the video footage and the available evidence, it will be hard to tell whether a jury will find that he had a reasonable belief that his life was put in danger by the protesters. One of them had a gun, and the other jumped on him. Right? We saw that. We all watched it together. These are facts which will likely be discussed over and over and over again. Additionally, it is not immediately clear whether he had exhausted all other reasonable alternatives. Remember, this does not have to do with whether you would have shot someone in that circumstance, but just whether a reasonable person could have believed that their life was in danger and had no other alternatives. With the available footage, it could go either way. Okay? It can. Regardless, since there is such a strong argument, at least in my personal opinion, for first-degree intentional homicide, there is a good likelihood that he will get at least second-degree intentional homicide if he's able to perfect a defense of self-defense, if not either degrees of reckless homicide. Okay? So that's the best I could do with a legal analysis, all right? That's the best I could do, just talking about this from an educational perspective, from the work that, I and other people have helped me with. That's what I can tell you about the law. Now, what do I think about this from a moral perspective? All right? This is a lot easier. I think that Kyle is morally in the wrong here. I do. I actually think this is a super easy one for me, personally. Even though I listened to the whole Destiny Vosh debate about this the other day. I listened to it. I listened through all of that. That was a ride. All right, that was a ride. The reason why is because he acted with blatant disregard for the law and chose to bring a deadly firearm somewhere, even though he had no right to have it. He wasn't 18. He literally committed a misdemeanor by bringing a gun somewhere where he wasn't allowed to have it. He had no authority to be able to have the gun there. And by doing so, he automatically assumed the risk that he may have ended someone else's life that evening. If people watch Vosh's debate with Destiny about it, this kind of relates back to Vosh's argument that he escalated force by choosing to bring a gun there in the first place. I think that's especially true given that he had no reason to bring it there to begin with. He wasn't allowed to use it. So when he ended the lives of other people that evening, I would say he became morally culpable for those deaths. That would be essentially my argument, right? It's amazing how much easier. I mean, like, a lot of this, like, can kind of piggyback off the analysis that we did for the, with the law, right? Especially, like, the part about him being underage. But yeah, like, I think that singularly determines it, at least for me, right? That's it. We've been on a journey, fam. I hope that this is helpful. Again, I'll say it one more time just to finish it out. This is purely for educational purposes. And if you want to know more, talk to an attorney, talk to like some legal professional, talk to someone who's bar certified. This is what I'm able to communicate to you as a student of the law. I did very well in my criminal law class, and my outlines where I got a lot of the information, at least like common law. I worked for a prosecutor's office this summer. And I used some of the info I got from there. But ultimately, like, I'm not bar certified, and I don't want people to think that I am. They don't want people to think that I'm drawing legal conclusions. I'm just trying to educate people, because I see a lot of misinformation being thrown around about this, and I see a lot of people saying a lot of things, and it seems like there's a lot of... It's unfortunate to see the discussion going the way that it is, right? So I hope that this proves to be helpful to people. I hope this, gives some people some insight. I'm glad that you stuck through it, because holy crap, was it harrowing for me. I just hope that this provided a pretty largely neutral analysis of it, right? Obviously, I have my own biases, but I hope it's clear that from my analysis that I just, like, stuck straight to the analysis, at least for the legal aspect of it.